Politics in Allegro. There's this commonly held belief or concept by people that for some reason the 14th Amendment was written and designed only to be applicable towards former slaves and the children of slaves who were freed after the Civil War. Now, I understand to some degree why people would come to this conclusion. It's spread around conservative newscasts like some sort of political herpes, but like a lot of the mainstream media and news, they pretty much never cite their sources as to why they think it applies this way. So let's break it down real fast. The 14th Amendment was ratified in 1868 after the end of the Civil War. One of the stipulations to Southern states who were part of the Confederacy to be allowed to rejoin the Union was to ratify the amendment. Now, it was originally written in response to the treatment Southern states were giving and the refusing to recognize of newly freed slaves as free legal citizens of the United States. While they couldn't discriminate against them due to their legal status anymore, they invented new reasons to be discriminatory, including the refusal of recognition of citizenship of former slaves who were freed in their territories. Contrary to right-wing talking points you'll hear blasted everywhere, it wasn't in response to the children of slaves, it was the slaves themselves, as the vast majority of them were already born on U.S. soil. Now, this was an assurance by the federal government and the U.S. Constitution that regardless of who you were or what your skin color was, you were an American should you be born on American soil. There was no need for anything remotely close to this prior to the war, as America was a melting pot nation. You could just show up on the shores of New York with a bag and a dream and become an American overnight. We were the land of opportunity before we even started marketing that, and the large portion of the white people currently here in the United States have those same origins for their families. A few months short of 30 years after the ratification of the 14th Amendment, it was put to test by the son of a Chinese laborer named Wong Kim Ark, who was experiencing issues after a short visit to China to see his parents and family in 1895. His parents were foreign laborers, briefly living in San Francisco, but were legal citizens under the Emperor of China. They were not official diplomats or government employees, though. Wong Kim Ark himself was born in San Francisco in 1873 and had lived there his entire life, only making short boating trips to China to meet family, as many immigrant families have and continue to do to this very day. Ark's parents moved back to China in 1890, while Ark stayed to be an American citizen. When he was attempting to dock back on American soil from his trip to China, the customs official denied his return to the United States by stating that he was not a legal citizen of the United States due to his parents being foreign workers and not citizens themselves. Ark tried to assert that he was born on U.S. soil, but the customs officer rejected this as a validation of legal birth. The lawsuit went up to the Supreme Court, who made their final decision on March 28th of 1898, based on these claims by the district attorney on behalf of the U.S. government. Because the said Wong Kim Ark, although born in the city and county of San Francisco, state of California, United States of America, is not, under the laws of the state of California and of the United States, a citizen thereof. The mother and father of said Wong Kim Ark being Chinese persons and subjects of the Emperor of China, and the said Wong Kim Ark being also a Chinese person and subject of the Emperor of China. Because the said Wong Kim Ark has been at all times, by reason of his race, language, color, and dress, a Chinese person, and now is, for some time last past, has been a laborer by occupation. That the said Wong Kim Ark is not entitled to the land in the United States, or to be or remain therein, because he does not belong to any of the privileged classes enumerated in any of the acts by Congress known as the Chinese Exclusion Acts, which would exempt him from the class or classes which are especially excluded from the United States by the provisions of said acts. Wherefore, the said United States Attorney asks that a judgment and order of this honorable court be made and entered in accordance with the allegations herein contained, and that the said Wong Kim Ark be detained on board of said vessel until released as provided by law, or otherwise be returned to the country from whence he came, and that such further order be made as the court may seem proper and legal in the premises. The decision they came to was the following: that ever since the birth of Wong Kim Ark, At the time of place, herein before stated and stipulated, he has had but one residence, to wit, a residence in the state of California in the United States of America, and that he has never changed or lost said residence or gained or acquired another residence and there resided claiming to be a citizen of the United States. That in the year of 1890, the said Wong Kim Ark departed for China upon a temporary visit and with the intentions of returning to the United States, and did return thereto on July 26, 1890, on the steamship Gallic, and was permitted to enter the United States by the collector of customs upon the sole ground that he was a native-born citizen of the United States. That after his said return, the said Wong Kim Ark remained in the United States, claiming to be a citizen thereof, until the year of 1894, when he again departed for China upon a temporary visit, and with the intention of returning to the United States, and did return thereto in the month of August 1895, and applied to the collector of customs to be permitted to land, and that such application was denied upon the sole ground that said Wong Kim Ark was not a citizen of the United States. That said Wong Kim Ark has not, either by himself or his parents acting for him, ever renounced his allegiances to the United States, and that he has never done or committed any act or thing to exclude him therefrom. The crux of the decision came down to two factors. Was Wong Kim Ark a subject to the jurisdiction of the United States of America upon his birth? Where did his allegiance lie due to that? And did he hold any residencies in China that would make him subject to the jurisdiction of the Emperor of China? The wording of the 14th Amendment is already stated, requires the person born in the United States to be subject to the jurisdiction of the United States. Jurisdiction is the legal authority of the federal and state governments against somebody, usually within their land or borders. Now, you probably think this applies to everyone, but you'd actually be wrong there. Foreign diplomats and emissaries of other countries have something known as diplomatic immunity. It's a legal protection that means the diplomat, while they are in the United States, is exempt from most of the host country's laws while in their borders. This has become a problem in the past, especially here in the United States, with diplomats doing everything from drug offenses to attempted human trafficking, where the diplomat's allowed to walk away from the situation without any jail time or punishments due to not being subjects to the jurisdiction of the United States. Due to this, children born to diplomats in the USA are not considered legal U.S. citizens per the 14th Amendment, which the U.S. Immigration Services actually has an entire green card process for children of diplomats because they have never been subject to the jurisdiction of the USA and therefore cannot be American citizens without going through the green card process like everyone else. For more information, look into 22 USC 4304 Bravo or 4304B. I'll include a picture of it on the screen. Finally, the allegiances. Specifically, if someone renounces their American citizenship, if you declare your resignation of your U.S. citizenship without filing any documentation stating as much, nothing really happens unless you piss off the government and they revoke it for you. But if you officially renounce your citizenship, that's the end of your legal entitlement to being on American soil, even if you were a legal citizen. Once you renounce it, you are considered a foreigner who has to go through the immigration processes as well. Ark was born to laborers, not diplomats, and was proudly declaring himself an American citizen, and never denounced his citizenship. He lived his entire life in the United States. He only left on short temporary visitations to China where his parents and family were living. If vacationing revoked your citizenship, our tourism culture would fall apart overnight. The Supreme Court who upheld the 14th Amendment were people who lived through its ratification. Ark himself was only born 5 years after the ratification of the 14th Amendment, and the people claiming it was a decision made long after the amendment and was being misinterpreted is blatantly incorrect. The Supreme Court justices who voted on Wong Kim Ark would have been lawyers during the height of the 14th Amendment ratification, and the last justice from the time period of the Civil War to die did so in 1877, only 20 years prior. This would have been justices who likely would have known about the reasoning behind the 14th Amendment as recent news. They're as close to the 14th Amendment as we are now to the Gulf Wars and 9/11. And before someone says something about, oh, well, if that's the case, then why didn't Native Americans get citizenship until 1924? That's right back to the issue with jurisdiction. While we now understand today that reservations are special land on American soil where indigenous tribes can make their own laws and enforce their own rules without much federal interference, that was not always the case. Prior to 1924, reservation land was legally considered an actual genuine foreign nation within the United States. The indigenous people born in reservations were not subject to any of the laws or regulations within the United States, and thus were not subject to the jurisdiction of the United States, and the USA gave up its rights to enforce its laws within the borders of reservation land with extremely small exceptions. This was changed in 1924 with the passing of the Indian Citizenship Act of 1924, and that guaranteed that people born on reservation land were also U.S. citizens because of this understanding that while tribes kept their right to self-governance, there was a mutual understanding that the reservations were still land within the United States, and that while the federal government does not rule it, it works hand in hand with the tribes on enforcement matters, so as a result, the people within are just as American as those born outside of the reservation. Never once anywhere does it specify in any documentation on the ruling that the 14th Amendment only applied to the slaves freed after the Civil War or to their children, even when the government was arguing against Ark back into the country when he wanted to come back in. The argument has always been about the jurisdiction which a child was born and their intent to stay here. If anyone ever tells you anything else, demand citations or proof because literally nothing actually on the book says otherwise. There have been unofficial personal opinions shared by representatives numerous times throughout history, but until the courts themselves with a majority opinion or an amendment states as much officially, the law of the land as it stands affirms the rights of all people born within the confines of the United States to be people capable of arrest and jailing thereof by the government for crimes committed within, who call themselves citizens, the rights as American citizens under our nation's protection.